My co-founders diluted my shares to 0% before a $100 million exit. I owned the code. I sued and took $30 million. I built the core algorithm for data flow in my college dorm room. For 5 years, I worked 100-hour weeks as the CTO, sleeping under my desk, while my two co-founders, Alex, the CEO, and Ben, the CFO, handled the business side. We were best friends, or so I thought. When we finally received a $100 million acquisition offer from a major tech giant, I was ready to pop the champagne. My 30% equity stake was going to make me worth $30 million. But 3 days before the deal was supposed to close, Alex called an emergency board meeting. I walked in expecting a celebration. Instead, they handed me a termination letter. They had used a loophole in the bylaws to execute a hostile recapitalization, diluting my 30% stake down to a microscopic 0.03%. They laughed and told me I'd be lucky to buy a used car with my payout. But Alex and Ben forgot one crucial detail from our sloppy startup days. In their rush to incorporate, they never made me sign the intellectual property assignment agreement. Technically, the company didn't own the code worth $100 million. I did. 5 years ago, we were just 3 broke students. I was the technical genius, Alex was the charismatic salesman, Ben was the numbers guy. I trusted them with my life. The acquisition offer was a dream come true. A Silicon Valley giant wanted to buy Dataflow for $100 million. We were all going to be rich. Or so I thought. The Friday before the deal was set to be announced, I was summoned to the conference room. Alex and Ben were sitting there with a team of expensive corporate lawyers I had never seen before. OP, Alex said, not making eye contact, the board has determined that your performance as CTO is no longer meeting the company's needs for the next phase. You are being terminated for cause, effective immediately. I was stunned. For cause? I built this product. The code is perfect. Ben slid a document across the table. We also voted to restructure the cap table this morning. We issued 50 million new shares to the management pool. That's me and Alex. Since you are no longer management, you don't participate. Your 30% stake has been diluted to approximately 0.03%. They had washed me out. They triggered a clause that allowed them to issue infinite new shares to themselves, rendering my slice of the pie worthless. My $30 million was gone. "This is illegal," I shouted. "It's perfectly legal," the lawyer smirked. "Read the bylaws you signed 5 years ago. Now please hand over your laptop and security badge. Security will escort you out." I was thrown out of the building I helped pay for. I stood in the parking lot holding a box of my personal belongings, watching Alex and Ben high-five through the glass window. They were celebrating stealing my life's work. I went home and collapsed. I felt stupid. I had focused on the code and ignored the legal paperwork. I thought I had lost everything. The next morning, I called a shark of a lawyer named Miss Vance, specializing in intellectual property litigation. I told her the story, expecting her to tell me I was screwed. She listened quietly, then asked one very specific question. "OP, do you remember the day you incorporated the company? Did you sign a document called a PIIA, a Proprietary Information and Inventions Assignment Agreement?" I paused. I remembered signing the bylaws, I remembered signing the offer letter, but the PIIA? That was the document that legally transfers the code I wrote personally to the company. I don't think so," I said. "We were doing everything on LegalZoom. We were messy." Miss Vance's voice dropped an octave. "OP, if you never signed that document, then Dataflow doesn't own the algorithm. You do." The company was about to be sold for $100 million, based entirely on the value of my code. If I could prove I still owned the copyright, the sale would be illegal. How did Miss Vance and I conduct a stealth audit of the company's original filing cabinet using a digital backup I kept on a personal drive to confirm the fatal missing signature that gave me the power to freeze the entire $100 million merger?
I raced home and plugged in my old external hard drive. Back in the early days, I was the admin for our Google Drive account, and I had a habit of creating a local backup of our legal folder every month. I searched for the folder dated 5 years ago, specifically the subfolder named Incorporation Documents. I found Alex's folder. Inside was his signed offer letter and his signed PIIA. I found Ben's folder. His PIIA was there, signed and dated. Then I opened my folder. There was my offer letter. There was my stock purchase agreement. But the PIIA? It wasn't there. I remembered that day clearly now. We were launching our beta version. The printer had jammed. Alex told me, just sign the stock stuff now so we can file. We'll print the IP assignment later. We never printed it. I never signed it. Ms. Vance smiled when I told her. This is the kill switch, she said. Without that signature, you didn't transfer your copyright to the company. You just granted them an implied license to use it. But you can revoke that license. We moved fast. Ms. Vance immediately filed a copyright registration for the source code with the U.S. Copyright Office in my name. Then, the day before the $100 million acquisition was supposed to close, we dropped the bomb. We didn't just sue Dataflow, we sent a formal letter to the legal department of the tech giant trying to buy them. The letter was simple. To whom it concerns, we represent OP, the sole legal owner of the Dataflow source code. Dataflow Inc. does not own the intellectual property you're attempting to purchase. Any transfer of this code without my client's permission constitutes willful copyright infringement. We demand you cease the acquisition immediately. It was a nuclear strike. No public company will touch a startup with an unresolved IP dispute. It's called toxic assets. 2 hours later, my phone blew up. It was Alex. "What the hell did you do?" he screamed. "The buyers just put the deal on hold. They're threatening to walk away. You're destroying everything." "I'm not destroying anything, Alex," I said calmly. "I'm just protecting my property. You fired me, you diluted my shares, but you forgot to buy my code. If you want to sell my algorithm, you need to talk to me about the price." Alex slammed the phone down. The $100 million deal was frozen. The tech giant gave Dataflow 48 hours to resolve the chain of title issue or the deal was dead. Alex and Ben were desperate. They knew they couldn't force me to sign, so their expensive lawyers came up with a new, aggressive defense. They filed an emergency motion in court, claiming that even without a written contract, the company owned the code under the doctrine of work made for hire. They argued that because I was an employee and received a salary, anything I created automatically belonged to the company, regardless of the missing PIIA document. It was a strong argument. In many cases, employees don't own their work. If the judge agreed that I was a standard employee, my copyright claim would vanish, and I would be left with my 0.03% shares. The work-for-hire defense hinged on proving I was a W-2 employee from day one. But I knew something about our early financial history that Alex had conveniently forgotten to mention to his lawyers. For the first 2 years, to save money on payroll taxes, Ben had classified us all as independent contractors, 1099 MISC tax forms. How did I use a stack of old 1099 MISC tax forms to shatter their work-for-hire defense and prove that under federal copyright law, the code was legally mine because contractors own their work unless they sign a specific agreement? The emergency hearing was held via Zoom. Alex and Ben looked confident. Their lawyer argued passionately. "Your Honor, OP came to the office every day. He used company equipment. He was paid a monthly salary. Under the common law agency test, he was clearly an employee. Therefore, the code is work made for hire and belongs to Dataflow." The judge nodded, looking ready to agree. "Miss Vance," the judge said to my lawyer, "do you have any evidence to dispute his employment status?" Miss Vance didn't say a word. She simply shared her screen and displayed Exhibit B, the IRS 1099 MISC tax forms from 2018 and 2019. "Your Honor," Miss Vance said smoothly. For the first 2 years, when the core algorithm was written, the company did not classify my client as an employee. To save money on payroll taxes and benefits, the CFO, Mr. Ben, explicitly classified OP as an independent contractor. Here are the tax filings signed by Mr. Ben himself. Alex and Ben's faces went pale. They knew exactly what this meant. Miss Vance continued. Under U.S. copyright law, specifically the Supreme Court ruling in CCNV versus Reed, independent contractors maintain copyright ownership of their work unless there is a written agreement stating otherwise. As we established, there is no written agreement. Therefore, my client owns the code. The judge looked at the defense lawyer. Counsel, you can't have it both ways. You can't treat him as a contractor for tax purposes to save money, then treat him as an employee for copyright purposes to steal his work. The work for hire defense is denied. The ruling was immediate. The judge issued a preliminary injunction blocking the sale of the company until the IP dispute was resolved. The news hit the tech giant buyer instantly. Their general counsel called Alex and delivered a brutal ultimatum. We are not buying a lawsuit. You have 24 hours to settle with OP and get a clear title to the IP, or we're walking away. And if we walk, we will publicly disclose why, and no one will ever buy you. Alex and Ben were cornered rats. Their $100 million exit was hanging by a thread, and I was holding the scissors. They called me an hour later. Okay, OP, Alex said, his voice trembling. You win. We'll give you your shares back. We'll give you the 0.03% plus, let's say, $2 million in cash. Just sign the release. I laughed. $2 million, Alex. The deal's worth $100 million. My original stake was 30%. That's $30 million. You tried to steal it. The price has gone up. We can't give you 30%, Ben shouted. We've already diluted the pool. We'd have to give up our own shares. Exactly, I said cold. Here are my terms. I want $35 million in cash from the acquisition proceeds, and I want it paid before you two get a single cent. If the deal closes for less than expected, you take the hit, not me. They screamed, they threatened, they begged, but the clock was ticking. 23 hours left, 20 hours left. Finally, with 1 hour left before the buyer's deadline, Alex sent the revised settlement agreement. It was everything I asked for. But I wasn't done. I realized that if I signed, they would still get rich, just slightly less rich. I wanted to make sure they felt the pain of their betrayal. I added one final non-financial clause to the settlement that would destroy their reputation in Silicon Valley forever. I forced them to agree to a $35 million payout, but the non-disparagement clause they requested had a loophole. What was the humiliating public statement I forced Alex and Ben to post on the company's official LinkedIn page as a condition of me signing the IP transfer, and how did it ensure they could never start another company again? I had secured $35 million, $5 million more than my original 30% stake. The money was wired to my lawyer's escrow account, and the tech giant was finally ready to close the $100 million deal. But before I signed the IP assignment agreement, I focused on the one thing Alex and Ben truly cared about: their reputation. They had insisted on a standard, mutual non-disparagement clause, preventing me from bad-mouthing them. I agreed, but I added a single, powerful amendment. My lawyer presented it. My client will sign the IP release, provided the settlement includes a clause requiring Alex and Ben, as remaining founders, to post the following statement one time on the Dataflow LinkedIn page, immediately after the deal is announced. The statement I wrote was devastatingly precise. Dataflow wishes OP well. We regret the hasty and ill-advised decision to dilute OP's shares and terminate his employment without fully resolving the underlying intellectual property ownership. We acknowledge that OP is the sole inventor and copyright holder of the core data flow algorithm, and that his contribution was instrumental in the successful acquisition by Google. This omission was a severe failure of legal and ethical judgment on the part of remaining management. Alex was screaming on the phone, "This is professional suicide. We can't post that. It admits fraud." "It admits a failure of legal and ethical judgment," Miss Vance corrected smoothly, "which is true. If you don't post it, the deal dies and you get nothing. Tick-tock." With less than 30 minutes left, Alex and Ben signed. They chose wealth over honor. The deal closed that afternoon. My $35 million was released to me. Alex and Ben split the remaining $65 million, which was significantly less than the $70 million they had planned on getting before the legal fees and my additional $5 million penalty. But the real punishment came an hour later. The humiliating statement was posted on Dataflow's LinkedIn page. In Silicon Valley, a failure of ethical judgment and an admission of trying to steal IP is a scarlet letter. Alex and Ben's names were forever associated with betrayal. They tried to launch a new venture 6 months later, but no reputable VC firm would touch them. Their professional careers were over. I, the former CTO sleeping under his desk, became an angel investor, funding ethical founders and building my own venture studio, all thanks to a piece of paper I never signed. The lesson here is simple and vital for every founder. The person who writes the code owns the code. A PIIA is the lifeblood of a startup's valuation. For founders, never skimp on legal work. The moment a feature is written, you must secure the IP assignment. For technical builders like me, always keep detailed copies of your employment status and ensure your proprietary information and inventions assignment agreement, a PIIA, is signed, or verify that it was never signed. That single missing signature was my $35 million. Trust the contract, not the co-founder.